All right, ladies and gentlemen, this is Mr. Vanderpool. We're going to continue talking about the Supreme Court here. We're going to talk about the public influence on justices. So justices, ladies and gentlemen, are not elected. They are appointed by the president. It's a lifetime appointment, except for the fact that justices can get impeached and removed from office. However, justices are not entirely immune to public opinion, and there's a couple of reasons for that. Number one, because they're appointed by the president, generally the president is going to appoint somebody that agrees with him or her ideologically. So this president was elected by the people. He or she was chosen because of this bias, and because of that, the president is choosing a Supreme Court justice that agrees with him or her. So kind of in an indirect manner, the people choose a Supreme Court justice because they choose a president based on what he or she believes, and that president, based on what he or she believes, picks a member of the Supreme Court or the federal court system. So justices also are aware of public opinion and are aware that decisions that flagrantly go against public opinion will not be implemented. That goes back to the slide that we just dealt with, the problem of implementing policy or implementing decisions made by the Supreme Court. Now, you do have liberal versus conservative justices. So justices are supposed to be above politics. However, they do have personal ideologies. Warren and Burger were both liberal justices. Rehnquist, Roberts tended to be conservative. So Supreme Court justices do see the world through their ideological glasses. So here, also notice that we're talking about Warren and Burger and Rehnquist and Roberts. These are chief justices of the Supreme Court. So oftentimes you'll hear, well, the Roberts court decided this, or the Warren court decided this. When these court decisions are given names that they're under such and such a court, the name that is used is the chief justice at that time. All right, let's look at appointment. So the president appoints judges for all federal court vacancies. That includes the Supreme Court. Senate must confirm all nominations by majority vote. This is advising consent. So what ends up happening is the Senate Judiciary Committee is going to hold a hearing. They're going to grill the person that has been chosen, and ultimately they will report out to the full Senate whether they recommend this person or not. And then ultimately it's going to be the Senate by majority vote who's going to decide whether this person will be a member of the court. So related to this idea is the idea of senatorial courtesy. It was the tradition started by George Washington to seek approval from local senators over locally appointed judges. All right, so let's look at some constraints on the power of the federal courts. It's an adversarial system. Decisions must be made between two choices. The court can't necessarily just bring up issues. It has to be a justiciable dispute. The courts must judge actual situations, not hypotheticals. You also have this idea of a political question. Supreme Court justices can't necessarily answer political questions. So if there is an absence of law to rule on a case, and the court therefore is going to call on Congress to create law. So this limits the ability of the Supreme Court and the federal court system to rule on a case, because if there's no law to interpret, law actually needs to be written. Thus, it is a political question because the Congress needs to go ahead and create the law. So therefore, the Supreme Court can interpret it. All right, let's look at some of the checks on the Supreme Court. The president appoints all judges. Congress must confirm appointed judges. Congress may alter the structure of the court system, the number of courts and justices. The Congress has the power to impeach judges. Congress may amend the Constitution if the courts find a law unconstitutional. For example, the income tax was originally found unconstitutional, so Congress added the 16th Amendment in order to include income tax in the U.S. Constitution. Now we're going to take a look at judicial and political philosophy. So there's a tension between freedom and order and equality and freedom. And we're going to be talking about a couple of different views, a couple of different ideologies. So you have some justices that are liberal. They lean to the left on public policy and would vote Democrat. Generally, they are more going to be associated with judicial activism, which says that judges should interpret the law loosely, using their power to promote their preferred political and social goals. Judges are said to be activists when they are likely to interject their own values in a court decision. They are associated with what's called loose constructionism, that you should use multiple sources when you're making a decision. They're more likely to say that the Constitution is a living, breathing document that must be interpreted with the times. There's going to be a more broad interpretation of document language if a justice follows this philosophy of judicial activism. Then some justices are going to be more conservative. They lean to the right on public policy. They would vote Republican. They are more likely to practice what's called judicial restraint. Legislators, not judges, should make the laws. Judges are said to exercise judicial restraint when they rule closely to statutes and previous cases when reaching their decisions. They follow the original intent of the framers. This is closely related to strict constructionalist, where you only look at the text of a written document when making a decision. It's also very closely associated with a judicial philosophy of originalism, that when you take a look at a text, at a law, you need to take a look at the original intent of the authors, the original intent that they had when they wrote the law, and that is how the law needs to be interpreted. So this original intent, the original intent of the people that wrote the law, needs to be taken into account when you interpret the law. This is called originalism, very closely associated with strict constructionism and judicial restraint. All right. So we're going to describe the structure of the Supreme Court, and we're going to do for number 2, if you were a member of the Supreme Court, what would be your judicial philosophy? Would you be more of a judicial activist, or would you follow judicial restraint, and why? All right, pause if you need to, then do the summary. In a paragraph, we're going to describe what we have learned today.